They hit Elon Musk with a $3.2 million fine, thinking he'd just pay and move on. But what he did in that courtroom left even the judge completely stunned. It was supposed to be a routine morning inside courtroom 7B of the federal courthouse in Fresno, California. Rain tapped lightly against the windows. The clerk shuffled papers. Reporters sat bored, adjusting their cameras and sipping coffee from paper cups. Then the door opened, and Elon Musk walked in, alone. No security detail, no legal entourage. Just a gray suit, a dark tie, and an unreadable expression. People glanced up, curious but not shocked. Musk had been summoned for allegedly violating court protocol during a previous corporate litigation hearing involving one of his companies. According to the court's complaint, he had disclosed sealed details from the proceedings during a press event weeks prior. It was a breach of conduct, clear and simple, or so it seemed. Judge Deirdre Colton presided that morning. Sharp, precise, and known for her no-nonsense attitude, especially when it came to high-profile personalities. She looked up from the bench, met Musk's eyes for a brief second, and immediately returned to her notes. "Elon Musk," she began, her voice calm but firm, "you have been found in violation of federal court orders relating to sealed testimony. The fine is $3.2 million, to be paid within 14 days. There were no gasps, no dramatic pause. This was Elon Musk, after all. Billionaire CEO, media magnate. A few million? That wouldn't shake him. But something about the way he stood there, hands loosely folded, no reaction, no objection, caused a subtle shift in the room. Judge Colton leaned forward, perhaps expecting a reaction. "Do you understand the terms of the judgment?" she asked. "I do," Musk replied, his voice level. "But I'd like to respond now." Heads turned. A few reporters straightened in their seats. The man hadn't brought a lawyer, and here he was, asking to speak for himself in front of a federal judge. Judge Colton looked skeptical. "Mr. Musk, I recommend legal representation before continuing." "With respect, Your Honor," Musk said, "I think it's more appropriate that I handle this personally." She gave a slow nod. "Proceed." And that's when things began to shift. Musk reached into his inside jacket pocket and pulled out a single sheet of paper. It was neatly folded, no binder, no folder. He placed it on the table in front of him. "I'm not disputing what I said publicly," he began, "but I am disputing whether the gag order applied in the context it was used." That raised eyebrows. A legal gray area. He continued, "The order referenced in the contempt filing was tied to Section 35B of the protective hearing order issued on March 11th. But according to subsection 35B-3, public safety exceptions permit disclosures under federal fair use exceptions, especially when the disclosed content refers to stockholder impacting risks." Judge Colton blinked once. Reporters began typing furiously. "I only mentioned one aspect of a manufacturing process that, if misunderstood, could have been dangerous for consumer use. I didn't name names. I didn't cite protected documents. I referenced my own concerns based on what I saw firsthand." The courtroom grew quiet. Behind him, a paralegal leaned over to whisper something to a colleague. Even the bailiff, who had been watching the door, looked slightly confused. Judge Colton raised an eyebrow. "Are you suggesting that you're protected under federal whistleblower statutes?" "I'm saying," Musk replied, "that the fine being levied against me may contradict precedent set in Stansfield v. U.S. Tech Holdings, 9th Circuit, 2004, where the court ruled that executive disclosures that serve a public interest cannot be penalized under seal protection if the statements fall outside the original parameters of the gag." There it was, a specific case, a ruling, a dated precedent. It wasn't a flamboyant gesture. It wasn't showmanship. It was strategic, calm, surgical, and now everyone in that room knew it. But Judge Colton didn't like surprises in her courtroom, and Elon Musk had just flipped the script. She didn't respond right away. She sat back, fingertips pressed together, staring at the man who had just quoted circuit law like he belonged at the counsel's table. For a long moment, the only sound in the courtroom was the buzz of overhead lights and the occasional tap of a reporter's laptop keys. "Elon," she finally said, dropping the formality for the first time, "you realize that referencing precedent in this courtroom doesn't guarantee exemption. This isn't a theoretical argument. This is a federal penalty. Musk didn't flinch. I'm aware, but it's not theoretical if the penalty itself ignores its own framework. It wasn't what he said. It was how he said it. Calm, measured, like he had practiced the lines 100 times, but not in front of a mirror. It came from something else. Certainty. Not arrogance, not charm, just clarity. The courtroom's atmosphere had changed. The judge was no longer speaking at a man accused of misconduct. She was debating someone who might actually know what he was talking about. A reporter near the back whispered, "Why didn't he bring his legal team?" Another leaned over. He must have wanted to make this personal? And maybe he had, because by now it was personal. "Mr. Musk," Colton said, slipping back into formal tone, "are you requesting a formal motion to dismiss the fine?" "No, Your Honor. I'm requesting a reassessment based on Statute 12-8-7F, Provision 4. I believe the court's penalty exceeds the bounds of what that statute allows in cases where sealed disclosure is nonspecific and intended to address imminent shareholder concerns." He paused. "And I can provide examples of rulings that echo that logic." Judge Colton exhaled. "You're serious?" "I wouldn't be standing here if I weren't." There was something slightly off-putting about it. Not disrespectful, never that, just unusual. Like watching someone recite rules in a game they weren't expected to understand, let alone win. She motioned to the clerk, "Bring me the transcript from the March 11th hearing and get the full ruling from Stansfield versus U.S. Tech Holdings on my desk by this afternoon." The clerk stood and disappeared down the hall, leaving a sudden quiet in the room. "Elon," she said again, this time like a parent trying to understand their child's logic, "you do realize what's at stake here. You're not just calling into question a fine, you're challenging the limits of courtroom discretion." He nodded. "Yes, but respectfully, Your Honor, if a court can issue unlimited fines for statements that weren't protected by the actual wording of the gag order, then what's the limit of that discretion? Where does it end?" A man from the Securities and Exchange Commission, sitting behind Musk, scribbled something into a legal pad. Another attorney from a rival firm quietly slid his phone out and started typing under the table. This was no longer a simple contempt hearing. It had become something else, a moment, a pivot. The kind of moment that law students would write about years later, when a defendant chose not to fight the accusation with lawyers or theatrics, but with logic. Musk walked over to the side table, picked up a printed copy of the March 11th order, something he apparently brought himself, and handed it to the judge. "Pages 3 and 4, he said. "Third paragraph. You'll see the exception clause." Colton didn't even look up as she took the paper. Her eyes scanned quickly, her lips pressing into a line. "This court has discretion," she said. "But even discretion," Musk replied, "has boundaries." No one spoke. Then slowly she looked up, not with anger, not even annoyance, just something close to realization. She didn't dismiss the fine, not yet, but something in her expression suggested the certainty behind it had cracked. And if Elon had poked a hole in the dam, the real test was still coming. How far would the water go?